In the final stages of a real estate transaction, the buyer, seller, and their respective agents will prepare for the time when each party will sign the documents necessary to close their real estate transaction. The Real Estate Settlement Procedures Act, known as RESPA, along with the more recent Truth in Lending Real Estate Integrated Disclosure Law, known as TRID, requires that all transactions in which a buyer acquires a loan for the purchase of real estate must be settled using the 5-page closing disclosure form. This disclosure form is required to be given to the borrower for their review at least 72 hours prior to the final document signing date. Loan and settlement charges are not allowed to vary too greatly between the original loan estimate form and the closing disclosure form. The period of time required for review might allow the buyer to renegotiate fees or perhaps even take their transaction to a different lender. For many years, final real estate paperwork was prepared by the title company upon receipt from the lender, with the final instructions and closing package, which often didn't arrive until minutes before the scheduled signing. This could mean the buyers, sellers, and their agents were waiting in the reception area or at the settlement table while final settlement statements were being developed and printed. The first that any person involved in the transaction ever saw the final settlement statements was at the settlement table. Those days are gone. The Consumer Financial Protection Bureau now requires the borrower be allowed 3 full days in which to review their settlement charges and compare them to their original loan estimate form before the actual consummation occurs. This helps protect the borrower against unfair lending practices where additional charges are added as the transaction is closing that weren't previously approved by the buyer. This mandatory 3-day period for review of the closing disclosure form cannot be waived, even if the buyer is so eager to close the transaction that they don't care what the charges are. Because they cannot waive this waiting period, it's possible the agents involved in the transaction will have to renegotiate the closing deadline in the final days prior to settlement. Because any extensions or other changes in the transaction must be documented in writing, this means the licensees must prepare an addendum and have the buyer and seller sign it to extend the transaction deadline. It's crucial buyers, sellers, and agents work with reputable, well-educated loan officers and other settlement service providers who understand the laws regarding real estate transactions and financing. RESPA and TRID are federal laws, and licensees all across the country must abide by these rules. Professional real estate licensees help their clients understand charges associated with borrowing money for a real estate purchase. RESPA and TRID laws protect the consumer from unscrupulous lending activity and excessive charges associated with borrowing money for a real estate transaction. Because a renegotiation of the settlement and closing deadlines may be necessary, this exposes the buyer to the possibility the seller will refuse to agree to a renegotiation and accept a backup or alternative offer. Sellers don't have to agree to extend the deadline for a real estate transaction unless they've previously agreed to do so, as part of the original negotiations. If current market conditions are such that property values are increasing, the seller may want to sell their property to another buyer because it's become worth more than when the first buyer purchased it, even if only 30 to 60 days has passed since the original offer was accepted. Since the buyer will likely have paid for an appraisal and home inspection, there could be a lot of money at risk for the buyer. Some brokers have developed addenda to be presented on every real estate transaction when buyer financing is involved, which states that the buyer and seller agree the settlement and closing deadlines can be extended by up to 1 week, in the event government regulation requires such an extension. With that agreement ahead of time, the buyer will have less risk. Talk with your broker about this type of addendum. The brokerage attorney may have already prepared a pre-printed addendum for this purpose to be used by the firm's agents. Typically, as the consummation deadline approaches, the agent and their client will schedule an actual time to sign documents at their title company. Unless there are unusual circumstances, it's best to schedule separate times for the buyer and seller and not have them both at the title company together. Settlement costs charged to each of them are confidential and should not be shared with each other. This can also be a very emotional time. Assuming they've gotten along in the transaction thus far, schedule each one with their own document signing time and arrange a later time after the actual settlement closing is completed for them to get together if they'd like to do so. Sometimes sellers want to share information about their home and what they've learned about it through the years. Buyers like to know how to turn on and off the sprinkler system and find out which day is garbage day. A friendly meeting can be arranged after the transaction has settled and closed. Scheduling such a meeting beforehand could cause stress for one or both parties. The buyer and seller may each decide at which title company they would like to settle their transaction and purchase their title insurance. The seller provides a title insurance policy in the amount of the purchase price for the buyer. If the buyer is acquiring a loan, the lender will require the buyer to purchase title insurance for their loan amount, ensuring the lender's position in the property. Since they will each have costs, the buyer and seller may each choose their own title company and sign their transaction documents at their respective title companies. However, inform your client that there could be a slight delay as the monies are transferred between the lender and both title companies. For some buyers and sellers, the availability of funds and access to the property are more important than choosing their own title company. Expediting the availability of the seller's funds and the buyer's ability to move in quicker may be most important to them. Title companies are regulated by the Insurance Commission and should perform their duties in an unbiased, impartial manner, regardless of whether they're working with the buyer, the seller, or both parties in the transaction. Professional real estate licensees should take time to explain the process of consummation, signing documents, and settling the transaction to their clients at the time when their clients are negotiating the actual sale or purchase, and again as they move toward that point in their transaction. You don't want buyers showing up at the title company with their moving truck expecting to get keys to the house that day, and it isn't fair to let sellers think they will be leaving the title company with the proceeds from their sale. Often, some of the greatest stresses in the transaction for the buyer, the seller, and hence their agents is this time frame from signing the final closing disclosure form and loan documents until the time they take or give possession of the property. Emotions can run very high for some clients during this time frame. Make certain to take extra time needed to help your clients through this process. Many agents like to take their clients a gift at this time. There are lots of real estate-themed ideas, such as door knockers engraved with their buyer's name, a welcome mat for their front porch, or perhaps just gift certificates for pizza delivery on moving day. Sometimes, as you're showing buyers various homes, a theme will develop, such as a desire for a garden area, in which case a set of garden tools could be a personalized gift. Perhaps a seller really wants to sell but can't afford to offer the buyer the home warranty they desire. A licensee may decide to offer to pay for the home warranty as their gift to the seller. There is no limit to the value of a gift a licensee may provide the buyer or seller in a real estate transaction. A licensee could send their clients on a trip to Hawaii as a closing gift. However, a licensee should always talk with their broker before participating financially in any way in the transaction. If the agent will give anything to the buyer to help them with their purchase, the lender must also be notified. Otherwise, the licensee could inadvertently participate in double contracting, a severe licensing violation. Common sense should prevail.